For this episode of Scholar Talks, the guiding question is, how did the natural law shape the American founding? Now, our guest Kody Cooper is a professor at the Institute of American Civics at the University of Tennessee, Knoxville, where he teaches political theory, political philosophy, and constitutional law. He has contributed to the BRI Government and Politics resource online and is the author of two books, including Thomas Hobbes and Natural Law and The Classical and Christian Origins of American Politics, Political Theology, Natural Law, and the American Founding, co-authored with Justin Dyer. And that book is today's topic. I am Tony Williams, Senior Fellow at the Bill of Rights Institute, and I am pleased to bring you another episode in the America 250 series of Scholar Talks. Kody, I want to thank you very much for joining me.
Thank you. It's a pleasure to be here.
Yeah, I really enjoyed the book. Just a comprehensive look at natural law, how it shaped the American founding from the very early resistance movement all the way up through the Constitution. So we'll look forward to hearing more about that.
Good. Yeah. I'm excited to talk about it.
Great. Well, let's get to it. Can you briefly explain what natural law is in a nutshell, and how is part of the classical Christian, those different influences on the American founding?
Yeah, good. You can talk about natural law in really complex ways or more simple ways. I like to start with G.K. Chesterton, his definition of it, which I think is nice and concise. He defined natural law as, quote, right reason in things which man, with his unaided reason, can see to be right, end quote. And that sort of definition draws from a long classical and Christian tradition, and specifically his own Thomistic school of philosophy. The core claim in natural law philosophy is that right reason, or in the Latin, recta ratio, can discern the functions of things and thereby judge whether human action, at either individual or social or legal plane, accords with proper human functioning. The core idea is rooted in this teleological understanding of nature that you can find articulated in classical sources like Plato, Aristotle, Cicero. And the great medieval Christian thinker Thomas Aquinas synthesized these classical sources with biblical revelation, with Christian with the Christian tradition. And his achievement was to articulate a sort of grand architecture of natural law as God's manifestation of the eternal law, or God's governance of the whole universe, as made known to human reason. The idea is that God impresses purposes on things in creating them, and that these are knowable and indeed known. And Aquinas also drew from non-Christian sources, Jewish and Muslim sources, because the claim of natural law is that in as much as a being has reason, it can know and indeed does know the first principles of the natural law, the most basic principles of morality. And so natural law philosophy then was metaphysically theistic. It wasn't only that in conscience there are certain things that ought to be done and are not to be done, but that sort of at the metaphysical ground of it was a creator, a legislator, as it were. And you could find this tradition all the way up into the Anglo-American tradition of jurisprudence, of philosophy, legal thought. Someone like William Blackstone, who is one of the great sources for legal philosophy for the founders, talked about natural law and in a theistic way. So, for example, he said, quote, when the Supreme Being formed the universe and created matter out of nothing, he impressed certain principles upon that matter from which it can never depart, and without which it would cease to be. When he put that matter into motion, he established certain laws of motion to which all movable bodies must conform. Man, considered as a creature, must necessarily be subject to the laws of his creator, for he is entirely a dependent being. So when he created man and endued him with free will to conduct himself in all parts of his life, he laid down certain immutable laws of human nature, whereby that free will is in some degree regulated and restrained, and gave him also the faculty of reason to discover the purport of those laws, end quote. And so that's a standard, definition of natural law, and and connecting it to human law that you would find among the common lawyers and people like Blackstone, and which were direct influences upon the American founders. I could elaborate more on that if you want, but.
Yeah, no, I mean, well, what struck me in your answer is that, it traces like the classical origins, influences on the founders, the English tradition, the Protestant resistance theory, tradition, as well as, the Enlightenment as well. So all these strains are sort of supporting this idea of natural law, maybe different traditions, but generally reconciled in the minds of the American founders, I would assume.
Yeah, I think so. And this is it's quite controversial and contested among scholars, how to think about like what the predominant tradition of influence is on the American founding. And you certainly do find different strains of influence. You find, the founders going back to sources in Roman and Greek antiquity, but you also have them going to Enlightenment sources like Locke and others. And so, and then there are these sources like that look like they're coming out of natural law thinking, like Blackstone. And so, how to put it all together? I mean, I guess the argument of our book, of the book that Justin and I wrote, is that if some scholars talk about the founding as like a multiple traditions amalgamation, one metaphor that I kind of like is the idea of the blended Scotch, taking various like strains of whiskey to make the Scotch. But if you actually study the making of Scotch, there's a central unifying like predominant strain. And I would argue that's the natural law tradition. That's the thing that unifies it and brings it all together. At least that's the case of the book. And so, the proof's in the pudding of whether or not it kind of comes out. And the arguments that the founders made, whether leading up to the revolution or afterwards, and they're thinking about forming constitution, the federal constitution and the state constitutions.
Well, I think that's a marvelous metaphor. So, so- but moving on into the American Revolution. So, how does this natural law tradition then shape the arguments in the pamphlet wars of the 1760s, 1770s, in that resistance movement against Great Britain?
Yeah, and that's a really it's important and good question. Because the founders, or who the generation that would become, I guess, the constitution makers, they first had to win the intellectual argument over sovereignty in the British Empire and what the limits of authority were of Parliament. And so the Stamp Act and subsequent acts of Parliament that the Americans thought were tyrannical, they had to make a case for why that was the case. And the way the argument went was to try to appeal to a higher law. And that really was the crux of the matter was, is there a higher law that is to which the Americans could appeal when Parliament claimed sovereignty over the colonies? And when Franklin and others, James Otis, that pushed back against the Stamp Act, there was such an uproar that Parliament actually did repeal it. Then they immediately passed the Declaratory Act, which said that Parliament hath, and ought to have the right to bind the colonies in all cases whatsoever. And that really was that was unacceptable to the Americans, to the American pamphleteers, because they thought that was affirming a positivist account of sovereignty, or what could be called a Hobbist account of sovereignty. That is to say that Parliament, whether right or wrong, its law, its say so is the law of the empire, and to which there's no further appeal. And so, the natural law tradition provided an account of the limits of legislative authority to which the Americans appealed throughout the pamphlet debates, saying, no, look, there are certain, fundamental natural rights, and those are recognized at common law, that are being violated here, including the right to one's property to not be taken away without consent or representation, and a number of other rights that came to be thought to be violated once the empire sort of upped the ante with seeking to enforce its various acts and shutting down of Boston and all the stuff that happens. Um, there's a range of rights claims, of moral claims that the founders make, and during the pamphlet debates, and at least the case that we make is that has its moral foundation in the natural law tradition.
Yeah, and I just love just all the quotes and the use of just right up from Otis through Thomas Jefferson, Alexander Hamilton, John Dickinson, letter from a farmer, Thomas Paine, just like the whole pamphlet war. This just really came to the fore.
Mhm. Yeah, and there are what we tried to bring out there is, some more familiar founders, someone like
Mm-hmm.
Jefferson, people know more about, and I would consider myself among all the founders to be the founder I know the best. I'm working on a book on Jefferson. Um, but Jefferson wrote 20,000 letters. There's always something more to learn, but he articulates, obviously he writes the Declaration of Independence. He articulates an account of natural rights rooted in natural law that he thinks are being violated. But then there's also lesser known founders, someone like James Otis, who, he dies before the Revolution, but Adams, identifies him as sort of like the spark, the flame that lit the fire of the Revolution, because he was opposing, the British searches and seizures that he thought were sort of illegally being done right around the time of the Stamp Act and after. And he was a great orator, lawyer in Massachusetts, and he was very articulate and laying out the fundamental principles of natural law that informed the Americans' argument. And his pamphlet, one of the first pamphlets written, was one of the most widely read in England and the United States. So anyway, we do try to bring out some of the lesser known and some of the more famous founders to collect evidence for the thesis that the natural law tradition informed their thinking.
Hmm. Right. And so speaking of Jefferson, so how is natural law right at the very heart, the very core of the Declaration of Independence?
Yeah, that's a good one. That's a good question. Of course, we know that the famous sort of opening lines appeal to the laws of nature and nature's God, and the natural rights that of life, liberty, pursuit of happiness were endowed by our Creator with these certain unalienable rights. So I think that the theistic natural law tradition is right there, but the controversy, I guess, is this something that is radically modern and that breaks from the older tradition? Because you don't find in Aristotle that talking about natural rights, for example. Now I tend to think that you can oversell this idea of continuity, but I think that those who emphasize the radical break of the Enlightenment on natural rights, I think that's an exaggeration to say that someone like John Locke radically broke from the tradition. The way the founders read John Locke is at least possibly there's possibly daylight between what Locke really thought. Now, I happen to think that Locke is somebody who can be seen as within the older tradition, but there certainly is a more emphasis on individual rights claims, individual freedom. That's true, but that doesn't necessarily mean that it jettisons the older tradition, I would say. And that's perhaps a bit distinct of an argument, but I would say the founders read Locke in light of the Bible. They had the most quoted source among the founders. If you look at sort of the founding generations writing in the pamphlet debates and up to the Constitution. It's not Locke, it's not even Montesquieu, it's the Bible. And so I think that they tended to read the Enlightenment thinkers, with Locke in one hand, the Bible in the other hand, and whatever subversive radical ideas Locke may have had in his metaphysics, which indeed does seem to have some more distinctively modern ideas that reject the older tradition, at least arguably, like nominalism and other things. I don't think the founders are taken in by that sort of stuff. I think that they tended to see the idea of a divinely pedigreed moral law as providing a foundation, a ground for the pursuit of happiness in an ordered way, in a virtuous way, and that included a right to acquire property in order to, take care of one's family. It wasn't this acquisitive, possessive individualism that, I don't think, to sort of unleash the rapaciousness of man upon nature without any care for one's fellow man or for the environment, all this sort of thing. That's one way one maybe can read Locke, but I don't, and that, is sort of a kind of, total individualistic, atomistic rejection of the older traditions' understanding of community and virtue. But even if Locke really taught that, or that's what Locke himself really thought, I don't think the founders read him that way.
And yeah, I mean, very interesting, right? There's Locke, right, that we might see in a college seminar room, a graduate study, but then there's how the founders understood him, which may or not be accurate in the former regard, but that's how the founders read him.
Yeah, yeah, I think so, and so that is, I think, why when we talk about the Enlightenment influences on the founders, there's the thing is that there's a moderate Enlightenment or even moderate Enlightenments and more radical Enlightenments, and the radical philosophers, Rousseau and some of these folks. Yeah, Jefferson read Rousseau when he was in France, but Rousseau is not an influence on the founders. Indeed, the founders reject Rousseauian ideas of sovereignty, that the democratic sovereign, that the general will is sort of absolute. They totally reject that. The Constitution is grounded on the idea that they argued for in the pamphlet debates, was that government's essentially limited. Whatever sovereignty is, it is limited. It is limited in its scope of what government can rightly pursue. It's limited by the moral law, and the moral law is a foundation for those natural rights. They come together. Duty for the founders. It's frankly a lie that the founders, that some scholars have promoted, that the founders just only talk about rights and don't care about duties. Yes, the Declaration of Independence lists those rights, but it's not in a vacuum. The state constitutions have to be read alongside the Constitution, the Declaration of Independence, and there's a clear emphasis on certain duties and virtues that are necessary for all this to work. And so I think that rights and duties come packaged in their minds, and that's exactly what the natural law tradition teaches, is that, like, what's the foundation of your right to life? Well, the duty not to kill other persons unjustly. What is the foundation of the right to liberty? Well, the duty not to enslave unjustly other persons, for example. So these things come packaged together.
Right, good. So how does the American Revolution itself, how is that shaped by religion and natural law, and how is religion sometimes divided among the Americans, both in the clergy, various denominations? There's a contending views of the American Revolution.
Mm-hmm. Yeah, that's a good question too. So, of course, you can sort of get at this a little bit reading the Declaration, because the Declaration refers to our Creator, and it doesn't, for example, identify God as Yahweh or the God of Abraham or Jesus Christ or Allah. It leaves the name of God underspecified. I think that's partly because there was religious diversity and pluralism that was, pretty, maybe not totally unique, but fairly unique in world history. Of course, most most of the diversity was within Protestant sects. There was a plurality of many Protestant denominations, but you could also find Catholics. You could also find Jews, and indeed, there's even evidence of at least sometimes in colonial history there being maybe a Muslim or two around. Again, tiny percentage, but the idea is that what's the public philosophy of the founding generation going to be with regard to religion? It's an inclusive one. It's a theistic public philosophy that there is a God, that this God is the source of the moral law, the source of rights. And within that framework, there is toleration and there's religious freedom. So, this, the question might immediately arise, like, oh, well, what about atheists? Are they included too? Well, a number of state constitutions required affirmation of theism, or even more specifically, affirmation of Christian faith to serve. And so there was this thought, even in Locke, that you actually can't trust the word of an atheist. Now, that doesn't necessarily mean that we're going to go on a witch hunt and try to smoke out the atheists, but it was a theistic consensus, which everyone signed on to practically. And that consensus concluded the more Enlightenment, skeptical, what we sometimes call deists, people like Benjamin Franklin, people like Jefferson. But I would emphasize that within deism, that's a broad tradition. English deism really sought to try to reread the Bible in light of historical criticism, in light of the new science, but they didn't, at least some of them did not deny particular providence, that God still governed the universe, or even necessarily denied miracles. And the founders pretty clearly, at least in their writings, if they're not lying, affirm particular providence. Benjamin Franklin famously has a speech at the Constitutional Convention in which he says that if a sparrow cannot fall to the ground without God knowing, how could an empire rise without his aid? And some scholars think that that's a sort of a big moment of change in the faith in his life, but Franklin seems to believe in a providential God. And similarly with Jefferson, he says, I tremble when I reflect that God is just in the context of slavery, that God's justice cannot rest forever. In other words, God's going to intervene and punish us if we don't deal with this problem. Wow, that sounds particularly providential. That doesn't sound like the deist watchmaker God who sort of wound up the universe and went, to have a cup of coffee and just let things go on its own, as a kind of, a version of deism says. Whatever you would say about Jefferson or Franklin, they didn't believe that, at least if you take seriously with those comments. So, of course, they were not Orthodox Christians. Jefferson explicitly rejects the Trinity. He explicitly rejects, the godship of Christ. But my point is that he could sign on to this idea of a providential creator God, the public philosophy, the public sort of theology of the founding. But there's still, even in light of all that, leading up to the revolution, there were some, and then after the revolution, there were some who opposed the arguments of the founders on religious grounds. They thought that the Bible didn't justify resistance. They thought that actually the Bible required obedience to Parliament, and so you had an argument among Christian clergy over whether or not revolution was justified, and a lot of those arguments turned on how do you interpret Romans 13, for example, which is one of the places in the New Testament where Christians get a little instruction about how they ought to relate to the government, to the king, to the laws. And Paul there talks about the need to show honor, respect, obedience to established authorities because they're established by God. And so throughout the history of Christian theology and thought, there's been this sort of discussion over when, if ever, is resistance justified, and so the American clergy, kind of get caught up in this conversation and in the pamphlet during the pamphlet debates, and the patriots sort of divide against the loyalists, and and theological terms as well.
Great, great. And so how is natural law important as well to the Constitution, right? We saw the resistance early on, and so we sort of see it at the other bookend of the Revolution and founding. How is it important to the Constitution?
Yeah, it's a huge question because it implicates, we the Constitution is still operative today, at least in theory. And even if we've sort of violated in a lot of ways and sort of rewritten in a lot of ways, and just in terms of judicial Supreme Court decisions, but it it is still the law of the land, and it and if natural law plays some role in it, and how we should understand it, then that has implications for today as well. So it's a big question. And of course, it's a great controversy. How do you interpret the Constitution today if natural law did play a role in it? I don't necessarily know if we need to get into those debates, but it may have implications. But I do think that it's presupposed, that there, when you read the Constitution, it doesn't have a lot of moral language. It doesn't have this sort of, God endowed us with natural rights. Now, here, when we created Congress. So some people read that to say, oh, this is kind of a moral document. It's a secular document. It doesn't have anything to do with all that stuff. Well, I guess I think that's a mistake, because I think that it's not as if like Madison just sort of forgot and Hamilton's like, oh, we forgot what we fought for. It's a practical document for arranging institutions and power in a way they think will best protect natural rights. And whether in Federalist Number 2 or other places, the Federalist Papers, the founders, Jay, Hamilton, Madison, they reaffirm the point of this is that the foundations of laws of nature to secure natural rights, even if we're not like talking about that explicitly in the Constitution, that is the point of this. And if you lose sight of that, then you've lost the thread. But the founders are very, very pragmatic, practical men, and they sought to arrange power and institutions in a way they thought would best conduce to ordered liberty, to the pursuit of happiness. And so they fractured power at the federal level between judicial, legislative, executive, and they fractured power, as it were, horizontally and vertically between states and federal government. And Madison famously talks about this in Federalist Papers like number 51, about how this sort of fracturing of power is to guard against the frailties of human nature. And this is one of the things about natural law. It's often forgot. It's one thing to say there's a natural law that we ought to do. We ought to live by certain principles in order to flourish. There's another thing to say we do that. In fact, we fail a lot, human beings do, to live up to live how we ought to. And the founders knew that, and that's why Madison says, if human beings were angels, no government would be necessary. Human beings, what he's saying there is that we are morally frail, or if you want to, use Christian terminology, we're fallen beings. And what that entails is that we even the most virtuous among us should not be trusted with absolute power. There's not many Aragorns around, that we want to make king, and so we ought to have auxiliary precautions as a way to try to guard against the frailty of human beings, and also to try to prod us to more deliberation, to seek the most wise policies when we deliberate about how to legislate. So I think all of that presupposes a natural law moral framework, of course, and then the specific amendment in the Bill of Rights, you get more precise specifications of certain goods, certain values that are thought to be essential for human flourishing, like the ability to think and speak freely, which was thought to be, teleologically oriented toward the truth, that we need to be able to think and speak freely when it comes to freedom of speech, freedom of press, free exercise of religion, because of the duty to pursue the truth, because of our purpose as rational animals to seek truth. This is going to facilitate that. we ought not to have our property taken without due process of law, precisely because it is an aspect of our practical requirement to flourish as rational animals, to acquire and possess property. Um, those are just a couple of examples of how, or I'll give you one more. We ought to have the right to keep and bear arms because there is a natural right and duty to self-preservation and self-defense. And indeed, the Supreme Court has for some and rather incredibly recognized that. Wow, they when they went back in DC v. Heller, and Justice Scalia wrote that opinion, he saw that the evidence is overwhelming that actually in the founding generation there's a natural right to self-preservation that the Second Amendment was seeking to codify. That's the reason why it's there. One loses the thread about what the point of this if one just ignores all the natural right, natural law language, as if it's this kind of just sort of hey, we want people to be able to have guns. Okay, well, why? So yeah, there's some evidence I think there.
Great. I think that sums up Lincoln rather nice. Lincoln said it well. I think that nice tie between the Declaration, the Constitution, the apple of gold, and the picture of silver. I think that's what we
Yeah,
see. So in a nutshell, wrapping things up, last question: how did the natural law shape the American founding?
yeah. So I mean, I think that it is you don't have the same country, you don't have the same founding institutions and documents without that intellectual tradition to stand upon. When I talk to students about this, sometimes students will be like, well, you know, why are we talking about the influence of Christian natural law and the Bible? Like, what about say, the holy documents of Buddhists or Hindus or something like this? And it's like, well, those are important things to study, but they weren't, that wasn't the tradition that led to the Declaration of Independence and the Constitution, right? You don't have a Declaration of Independence pop up in the Far East in, 1776. Why?
Mhm.
Ideas matter. I mean, that's not to say that you can't find in Confucius say, um, the rudiments of natural law thinking and the other Far Eastern thinkers, one would expect that one would find such evidence if indeed natural law is made known to all human beings. So that's a little bit of the riddle. What's distinctive about the American, what came out of the American sort of founding? And it's not just a pure unadulterated natural law reason in the abstract, but it is a specific tradition coming out of European and Anglo-American thought and jurisprudence that is shaped by Christianity and more specifically Protestant Christianity and common law thinking. So there's a lot more complex that can be said here, but it is a sort of simple version of it is a kind of Christian natural law tradition that that forms the soil from which this grows out of. And again, I think that that's one of the stronger proofs is to go to comparative politics, to go outside of the context and ask why this didn't grow up in another place. And I think that you can't explain it without the presence of this tradition.
Mhm. Very good. All right. Well, Kody Cooper, I want to thank you for joining us to discuss this very important and maybe contrary to some of your students thinking, very relevant topic. So thank you.
Well, thank you so much, and yeah, love all the work that y'all are doing, and a pleasure to be here.
Thanks. Let us know when that Jefferson book comes out.
Okay, yeah.
Great, great. All right, and thank you all for joining us on this episode of Scholar Talks. Please check out the other interviews in our America 250 series on our channel and click subscribe.